Good afternoon and welcome to a webinar hosted by Corney and Lind Lawyers. My name is James Tan and I'm a senior lawyer at Corney and Lind Lawyers. And today I'm going to be talking about litigation funding in family law property disputes. What if I can't pay a lawyer? Which is a question that many people have asked themselves when they go into that difficult separation process. Firstly, just an introduction about Corney and Lind Lawyers. We're a mid-sized law firm with several focus areas: schools and education, not-for-profit and charity, commercial, employment and discrimination, personal injury, family law, estate and elder law. And quite recently, we've also added a few more practice areas, being migration and visas, criminal law and traffic law, and commercial and construction litigation. Our lawyers will travel to you if needed, and our specialist lawyers provide cost-effective, responsive solution. We're also conveniently located next to the CBD and opposite the Royal Brisbane Women's Hospital Transport Hub. Now, the presentation that I'm going to go over today, it's just in relation to litigation funding in family law property disputes. We're going to be covering a couple of things today. Firstly, I want to talk about the financial imbalance situations that commonly arise in family law situations. And then we'll be talking about the funding options that are available to the parties who may not be able to access funds in order to obtain legal representation. The third thing that I want to talk about would be making the most of your appointment with your lawyer. What evidence can you give your lawyer in order to assist them in managing your case in a timely manner, and also to assist them in arguing the funding options which we've discussed. Lastly, at the end, I'd like to make some time for questions. So if you have any questions, please feel free to type it in. And at the end of the session, if we still have time available, would love to answer your questions. So in family law situations, we commonly see what is known as a financial imbalance, or what I call a financial imbalance. And the scenario which I like you to imagine would be this traditional situation of a primary breadwinner and a primary homemaker. Um, this is something that we commonly see in family law with, for example, one party having the higher income earning capacity, that person being the breadwinner. Um, and we know that the breadwinner has spent their time in the relationship working hard, working the after hours, building up the businesses maybe, and spending a lot of time advancing in his career or her career, whilst the homemaker has instead spent their time at home, maintaining the home and caring for the children. Um, eh, the breadwinner has excelled in the career and develops the necessary skills in order to generate surplus income, buy investment properties, invest in shares, set up trusts, which the breadwinner has the intellect and the ability to manage. The homemaker's attention, on the other hand, has been devoted to the care and the love of the household affairs, which enables the breadwinner to go out and work. Unfortunately, this means that the homemaker has minimal opportunity to develop the career skills, um, lesser of an understanding of the financial projects which the breadwinner works on, and less control in that sense, and decision making as well in all those financial affairs. The breadwinner will normally have, with their skills and the management ability, uh, the control of these financial assets. Uh, the breadwinner may shift the matrimonial assets into family trusts or various family-owned business entities, or even investing into business entities that he owns by himself without any family relation. The breadwinner tends to be in control of these assets and financial resources. Sometimes we see circumstances where the homemaker has minimal knowledge of where the money went. In certain sadder circumstances, we see circumstances of economic abuse, where the breadwinner uses their control of finances to exert control over the homemaker. This is a form of domestic violence and is, frankly, unacceptable. At the end of the relationship, we also see certain traits that commonly pop up. We see the breadwinners wanting to retain the income-producing assets of the relationship, the businesses, the trusts, maybe, whilst the homemaker usually tends to continue to have the primary care of the children. Uh, Quite commonly, we see circumstances where the breadwinner has absolutely no idea how to raise children because they've been out and about working into career day in and day and night. So in family law, uh, the contributions of the homemaker, which are non-financial, and the contributions to the breadwinner, which are financial, are given equal weight. Uh, but despite that being the Family Law Act's position, we still have a very practical problem. The problem is that the homemaker has minimal access to funds in order to access legal representation. A breadwinner has the primary access to the matrimonial assets and the income. The breadwinner has the higher salary, the skills, and is able to regularly generate the income which goes directly into his bank account. The homemaker has minimal access to a high-paying job or savings because they've all been moved into for example, the homemakers, the breadwinners' companies or breadwinners' trusts. Navigating the separation process is emotionally difficult. Navigating the Family Law Act can also be difficult and expensive. Uh, Unjust and inequitable situations may arise where the homemaker has minimal access to justice and legal representation, particularly where the breadwinner themselves has the money to afford, say, expensive lawyers. Without legal representation, the homemaker may make uninformed decisions about the homemaker's rights. These decisions may have long-lasting effects that affect the life of the homemaker and the life of the children. Fortunately, the law has recognized that this financial imbalance can be an injustice, uh, and there are a number of different options that assist in restoring the balance. We'll cover a few of these options today. First option that I want to talk about is what lawyers like to call the Strawn Order, uh, or an interim property order. Before I go into a bit of the background of the case of Strawn and Strawn, it would be helpful to go over a few definitions for those who are unfamiliar with the family law property process. So under the Family Law Act 1975, the court has powers to make orders in relation to the division of matrimonial property. In general terms, the court follows a four-step process which evaluates factors such as what's in the asset pool, what are the assets and liabilities that form that pool. Um, for example, it can be the matrimonial home, the companies owned by the breadwinner, joint bank accounts, loans taken out, the credit cards of both parties. There also is a consideration by the court in the next step of what are the contributions of the parties. Contributions being, what did the breadwinner, for example, bring into at the beginning of the relationship? Uh, what work did the homemaker do throughout the relationship in terms of maintaining the home, or raising the children. And as I said earlier, these contributions are given equal weight. There's also the court. The court will also take time to consider the future needs of the parties. For example, is there an income earning disparity between the parties? Will one party have to spend more time taking care of the children because that party has an order for the primary care of the children? And lastly, the fourth step is whether it's just and equitable for the court to make such an order. So when the court has evaluated and gone through this four-step process, the court may decide to make a property order. For example, order that the matrimonial home be sold and 60% of the proceeds be given to the wife and the balance to the husband, or a payment, a lump sum payment from the bank account of the breadwinner to the homemaker. This is what we call a property order. And normally these property orders can be made on a final basis at the end of a long trial. The court also has the powers to make an interim order in circumstances where it's appropriate to do so. Difference between an interim property order and a final property order is that an interim property order is made during the proceedings before a final decision is made at the end of it, after consideration of all the evidence filed and the cross-examinations, all the other, so a final trial. So an interim property order is a property order in the middle of the proceedings, and this was the power that was exercised in the decision of Strawn. Strawn is a case that has it's a series of cases, I should say, with a long and extensive history involving multiple appeals and multiple pleas, including in this particular case from the Strawn case series, a plea for an interim property order. As a general background to the matter, Mr. and Mrs. Strawn were a very wealthy couple. At the time of separation, Mrs. Strawn had approximately $6.7 million in her bank accounts. At the same time, around the same time of the separation, Mr. Strawn gave evidence that he had a weekly income of $282,000, weekly expenses of $60,000, property of $35.5 million, liabilities of $852,000, and financial resources of $21 million. So by all accounts, Mr. and Mrs. Strawn had a lot of matrimonial property to fight over. In this particular application in the Strawn case series, the wife sought a further $5 million to pay for her legal costs by way of an interim property settlement. The trial judge only awarded her $1 million to go to her legal costs. The wife then appealed the trial judge's decision, and the result is great commentary about what information is required and what submissions are required to satisfy the court to make such an interim property order. So our observations from Strawn, we take the view that there are three main limbs to the test. The first is it appropriate or in the interests of justice to make an interim property order, as opposed to simply leaving it as it is, not making a property order, and waiting to the end of the matter before and making a final determination? In looking at this, the court will be interested in factors such as the financial circumstances of the homemaker. For example, is the homemaker able to meet their own legal fees without an interim property order? How is the homemaker living on a day-to-day basis? What sort of assets, income, and liabilities does the homemaker have? The second stage of the test is an interim order able to be made in consideration of the general framework of the four-stage process which we discussed earlier? As this interim property order relies upon the property order powers of the court, if the four-stage process can't apply to it, or if the court doesn't have jurisdiction to make such a property order, then this whole argument will fall apart. For the last stage, will there be any adjustment issues? And what this means is, for example, will the remaining property after the interim order be adequate to meet each party's legitimate expectations in the final order? Or will it be sufficient? Can the contemplated order be adjusted or reversed? To put it in a very practical example, to give you a practical example, I should say, if the court was thinking about ordering $50,000 by way of an interim property order to a couple where the whole property, the size of the entire property pool is, say, $75,000, then there may be an issue there, and a strong order may just not be appropriate, and the court will not be satisfied that there are no adjustment issues. The next option that I want to talk about is a spousal maintenance order. So what is spousal maintenance? Spousal maintenance is a payment from one party to the other party to provide financial support. For example, if we have one party who's generating a lot of income, normally the breadwinner, and a homemaker who has a lot of living expenses that they can't afford because they've spent their entire life working. They've spent their entire life caring for the home, and now they're forced out of the home and are having to pay rent and things of that nature, which they can't afford. Then a spousal maintenance order would go towards that sort of costs. Spousal maintenance. What kinds of spousal maintenance payments can be made? So spousal maintenance payments can be made in lump sum once-off payments or regular periodic payments. So that could be, say, a lump sum payment of 50 grand to cover off the spousal maintenance for the next 2 years, for example, or a regular periodic payment of 2.5 grand every month. The court has great breadth to be able to classify and allocate these spousal maintenance as payments to cover a party's legal expenses, or even to cover things such as the party's general living expenses like rent and food. Similar to a strong order, these spousal maintenance orders can be made at an interim stage of the proceedings, that is, before a final decision is made, or alternatively, the spousal maintenance orders could also be made at the end of the proceedings when a final determination is made. Our observations about what is required to satisfy the court are as follows. Is the breadwinner able to support the homemaker? Does the breadwinner have excess income to make these regular payments? If a lump sum payment is required, what sort of assets or savings are there to make this lump sum payment? Next question I like to ask is the homemaker able to support themselves? Or for that matter, if they have any parties which they are responsible to care for example, children that are in the primary care of the homemaker, which is again, like I said earlier, a common situation we see. So if there is if the homemaker is able to support themselves and the children and provide for the groceries to feed the kids, then the whole argument of a requirement for spousal maintenance may fall apart. The last thing that needs to be considered is what happens if the homemaker does not receive the spousal maintenance. And again, we need to talk about what injustices will happen so that the court can determine whether it's proper and reasonable to exercise the spousal maintenance power. So in summary, does the breadwinner have excess funds, excess income, or excess assets? Does the homemaker is the homemaker unable to support themselves? And lastly, what injustices will occur if spousal maintenance is not ordered? The next option that I want to talk about is a Hogan order or a Barrow order, or sometimes called a interim costs order. This is in reliance on a different provision of the Family Law Act, and unlike the interim property distribution or the spousal maintenance distribution, a Hogan or Barrow interim cost order is an order giving access to the party for certain funds that can only be used exclusively for the payment of legal costs. So that's why it's called an interim cost order. And the section 117 referred to earlier is a part of the Family Law Act that gives the family court, or the court, I should say, power to make cost orders. Our observations about what is required to satisfy the court to grant a Hogan order are as follows. Firstly, are there circumstances that justify the court making such an order? And again, we look at the injustices or the circumstances of the parties. Is there a financial imbalance? Are the breadwinner or the homemaker able to fund their own legal costs? Is there a suitable source of funds that will lead to injustices not being suffered? And what I mean by that, for example, is if the breadwinner is living in the house and the only way that the court could make this order would be for the breadwinner to sell that house and be moved out of the home, then the argument starts to become a little bit more difficult. The second question I ask is, would it be just for the court to make such an order? What happens to the homemaker if she's not provided with the funds? How has the breadwinner been conducting themselves throughout the proceedings? Have they been unnecessarily obstructive, perhaps not providing disclosure in a very obstructive way, or hiding money in third parties, for example? Was the breadwinner unsuccessful in any appeals or any interim applications? Have they been resistant to making proper offers of settlement? So these are other considerations which are normally taken into account whenever the court decides to make a costs order, but are also relevant in these circumstances as well, because the Hogan order relies upon the cost power of the court. There's also a dollar-for-dollar order. Slightly less popular these days with the common application of Strawn and Hogan orders. But there is still merit for a dollar-for-dollar order, particularly where there is no clear source of funds or there are there's other murkiness or ambiguities with establishing the elements that we discussed earlier for those respective orders. So a dollar-for-dollar order is essentially for every dollar that the breadwinner spends on legal representation, the homemaker receives the same amount of money to be paid for the homemaker's solicitors. And the term that's commonly used in decisions relating to the dollar-for-dollar order is a level playing field. So this means that each dollar spent by the breadwinner, the homemaker gets $1 as well. It's a very useful as an alternative to the earlier court powers I have discussed, particularly where the elements of those orders cannot be satisfied. Um, the last that I'd like to talk about would be legal aid funding. Now, legal aid is not, unlike the previous options, legal aid funding is not an order. It is government-funded legal representation. The strict eligibility tests that would need to be satisfied before a party is eligible for legal aid funding. The first is the means tests, and that looks at, for example, what are the income and assets of the parties. So that includes the homemaker and the breadwinner. So if the homemaker is, say, unfortunately, um, does not have much assets to her own personal name, but the breadwinner has a significant number of assets to their name, then then the homemaker may not be eligible on the means test because the parties have just too much joint income and assets. The second eligibility test is the legal problem, and does your legal problem fit the guidelines set by the government? Quite frequently, we see these days that the emphasis is on parenting and DV, domestic violence matters. So property matters may not necessarily get legal aid funding if it's a problem that's solely related to property matters. The last test, which I'd like to talk about, is the merits test, and that is whether there's any reasonable prospects of success. Or, for example, would a prudent self-funding litigant spend their own resources on such a case, or is there costs spent? Is the cost spent of benefit to the applicant? Or sometimes they'll look at the benefit to the wider community. So all of this is meant to put in place some strict guidelines in order to give funding, legal funding, to people who are unable to afford it, in dire circumstances, and need the legal aid funding. So I've talked about the various options that, various few options in relation to accessing litigation funding in family law property disputes. I'd like to briefly talk about making the most of your appointment with your lawyer. As discussed earlier, there are a lot of different elements to satisfy for each option that you may seek to rely upon. I would recommend bringing in the following documents to your initial appointment with your lawyer. If you anticipate needing to rely upon the options which I've described in this presentation, you should bring in your bank, loan, and credit card statements, and not just of you, but any joint accounts you may have, any statements which you may have access to that belong to your partner. That way, you're able to show what are the assets and liabilities, what's the cash currently held in the bank accounts, what is the expenditures and the liabilities of the parties, which all go to satisfy various parts of the elements in the matters I've discussed earlier. Any financial statements of companies or trusts that are prepared by accountants would also give a very good bird's eye view of what those companies are worth and what they have. Income, trusts, tax returns would also be a useful bird's eye view at showing what parties earn in a year, what have earned in the past financial year, what the trust has earned, and where that money is coming from. Pay slips, if there are any, will also show what is the income of the parties. Uh, Centrelink documentation, again, uh, disregard. And lastly, any emails, invoices, or other correspondences relating to the quality and life and expenditures of the parties um, may again uh, 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 show what are the financial resources and the expenditures of the parties. And all of these go to show, or go to establish the income, the assets, what is what property there is, what liabilities there are, uh, uh, and that all comes to play when satisfying the various elements that I've described for the options earlier. So that's it for the presentation and the material that I prepared. Um, if you have any questions, you may feel free to ask or type it in. We'll just give a moment or two for any interested parties to ask a question. It appears that there are no questions. So thank you very much for attending this webinar. My contact details are there available on the screen. So if you have any further questions, feel free to drop me an email. Thank you very much for attending, and I hope it was helpful to you.